Court is hearing arguments in a very important case for special education called Endrew F versus Douglas County School District. Under federal special education law, a child's IEP must provide a benefit to the child in terms of the help to get an education. But how much of a benefit should the school provide? That's the question before the court. In a moment, we're going to be talking to the lawyer for the family involved in the case, as well as two legal experts who are going to help break down what this might mean for your child. So thanks for staying with us for the next few minutes. Before we get to our first guest, I want to give you a little bit of background about the case. The case involves a boy named Drew who has autism and ADHD. He went to a public school district in Colorado and had an IEP. From kindergarten through fourth grade, he made very little progress on his IEP academic goals. He made so little progress that many of the goals were repeated from year to year. In fifth grade, his parents decided to pull him out of the public school and place him into a private school for kids with autism. Once there, he received behavioral services and started to learn and progress. His parents say that the reason he didn't make progress was because he didn't get the support for his severe behavioral issues. In this case, both sides agree that under the Individuals with Disabilities Education Act, Drew had a right to a free appropriate public education, or FAPE. What the parents are saying is that he was denied the right to FAPE because he got only a trivial benefit from his IEP. So the court has to decide, is it a trivial benefit or something more meaningful? To help us understand this case, we're joined by Jack Robinson. He's the attorney for the family in the case and just came out of the Supreme Court. Thanks for joining us, Jack.
Thank you.
Jack, could you tell us what the family hopes to accomplish by bringing this case to the Supreme Court?
Well, obviously the parents hope to accomplish or hope that the Supreme Court will decidedly reject the merely more than de minimis standard that the 10th Circuit and a number of other circuit courts of appeals have applied to what constitutes a free appropriate public education, and adopt and clarify a much higher, more robust standard, substantive standard of what equates to an appropriate education.
So basically, just to clarify that for our audience, the de minimis standard is what's on the books right now in the state where Drew's family lives, and you guys are arguing for a more meaningful benefit. Is that right?
Right. And, in this case, this is a perfect case, and this is maybe why the Supreme Court decided to take this case, was that, Drew, we argued he made no progress, but the 10th Circuit found that, without question a close case, that he, made minimal progress towards at least one goal in his IEP. But, this was in the face of, his entire education basically deteriorating behaviorally, communicatively, socially, functionally. He was deteriorating, yet he was able to do a little more in one area at the end of the school year than he did at the beginning, and the court said a little more than nothing is good enough for us. So,
okay. And in terms of the decision or that may be coming from the court, how will it help Drew if the Supreme Court rules in favor of the family?
Well, it will. He's 17 years old now, and so, it'll help. He's getting an appropriate education now, and that's what there was no dispute at the lower court levels that, the parents having to pay for his education is being provided, an appropriate education. This will, like I said, establish a sort of substantive standard that's higher than what was applied in Drew's case.
Great. And in a nutshell, could you give us what the legal argument that you have is for that higher, meaningful benefit standard?
Well, our argument is that the standard should be substantially equal opportunity to typical children. That the barriers to their learning, their education, should be removed, and they're able to achieve to their potential. As opposed to the 10th Circuit standard, which says if they go to school and they absorb something a little more than nothing, that's all the IDEA provides. And again, our argument too is that this issue of what constitutes a FAPE was last addressed by the court in 1982 based upon a 1975 statute, and that's from 40 years ago. And the IDEA has been reauthorized and substantially amended twice, once in 1997 and again in 2004, and we're not talking about the same equation in 2016 or 2017 now as we were, say, in 1975.
So standards evolve. Now we should have a more meaningful benefit as the standard for IEPs. Now, you've been with this family from the very beginning of this case, 7 years ago. Can you give us a sense of what they're thinking or feeling? What's on their mind right now?
Yeah, no, they're very, they're obviously very excited, cautiously optimistic. You can't even imagine, what a parent has to go through emotionally to challenge the school district, to hire an attorney to pursue this all the way up to the highest court in the land. It's not easy for them, and they are obviously very hopeful that, that it'll come to something. I think that, just us being here having this conversation is huge. That, hopefully that conversation will, will play out in the public, and that people recognize that what are we investing these millions of dollars in the IDEA for the education of children with disabilities when we don't expect anything, little more than nothing, and that, for the court to adopt something higher than that, will be huge to the parents and make this all worthwhile.
Great. And you said that Drew is actually doing pretty well right now. Isn't that right?
Yeah, no, he's doing great, and I think it was recognized in the court that he's made significant progress at Firefly, and you can only shudder to imagine what his living situation would be had he continued under that path at the public school as opposed to say what he received at Firefly.
I want to mention that Firefly is the private school where he is at, which serves kids with autism. As a final question, a lot of parents, families, and advocates are watching this case closely. They may have hopes for how it turns out. How does that make you feel as an attorney and advocate for kids? Words probably can't describe it. I've been, doing this, representing parents with children with disabilities for 20 years. And I have been in my practice in, trying to advocate for parents with children with disabilities, sort of saddled with this merely more than de minimis standard my whole career in this, and having, say, the Solicitor General stand up and adopt or validate the higher standard that I've been arguing for so long, and the prospect that the court will embrace that or some form of that, it's amazing. Yeah, that's great. Thanks so much for joining us, Jack. Best of luck on the case, and really appreciate you talking with us.
Sure. Thanks for your interest.
So the next we're going to talk to two experts who are going to help us understand what this case may mean for kids with learning and attention issues. Lindsay Jones leads public policy for the National Center for Learning Disabilities, one of Understood's founding partners and its managing partner. And Michael Uden was the top federal official for special education. He led the Office for Special Education and Rehabilitative Services as Assistant Secretary from 2012 to 2016. Thanks to both of you for joining us. I'll start with you, Assistant Secretary. Give us a sense of how important this case is to both kids and families.
Yeah, well, thanks, Andrew. This is a really important case. The Supreme Court is going to articulate a decision. They're going to enshrine a standard into law that will determine whether students with disabilities are only entitled to a more than merely de minimis standard of educational benefit. If you look up the term de minimis in the dictionary, that means to merit disregard, right? So what we know is that is completely incompatible with what research tells us is meaningful and effective in the education of students with disabilities. We know that it is incompatible with the best and research-based practices of teaching and learning, and it is inconsistent with federal law. The research tells us that kids with disabilities do better when they are held to the high expectations and have access to the general ed curriculum. So we need to move forward with that. We know that there are research-based strategies around response to intervention and positive behavior intervention supports and universal design for learning, and great research-based approaches that teachers are employing every single day in classrooms all around the country that really do help kids meet high standards. And of course, we have federal law that holds all kids to the same high standards of college and career readiness. And really at the heart of this is the IEP, the Individualized Education Program, and that's the mechanism in which kids with disabilities have the opportunity to have access and be successful in the classroom. And as was argued here today, and as the law clearly articulates, the IEP must be designed to ensure that kids with disabilities have the opportunity to advance appropriately and be involved in and make progress in the general curriculum. So a more than de minimis standard is really is incompatible with what the law and the expectations require.
Yeah, it sounds like de minimis is a very, very, very low standard, almost nothing or minimal. Lindsay, NCLD filed an amicus brief in this case. That's a legal paper in support of the family. Can you tell us a little bit about that amicus brief and what it says?
Sure. We were excited to do this and we were committed to doing it. We were happy to join with our nation's two largest disability rights law firms because, as Michael has just eloquently outlined, this case is the heart of IDEA. Really, it really is going. That standard that the court will determine is what every child in our nation will feel and see in every day in their education, all the educators who work with them. So the FAPE standard, free, appropriate public education, the right that is guaranteed under IDEA couldn't be more meaningful. And it was important we didn't want to sit down and not say anything. It was important to stand up and say, we believe that standard should be high. It should be one that is achievable, ambitious but achievable. So we had to join with everyone. We were very pleased, and it was, after practicing law for many years, it was an amazing experience to watch the justices speak about this, and I feel somewhat hopeful going forward.
I didn't quite enjoy sitting there as well. I was nervous, so it was tough for me.
Yeah, I can imagine it could have been a very nerve-wracking moment because so much is at stake. So much is at stake with this case. Now, we've talked a lot about what the family is arguing, what they want. Help us understand what the argument from the school district is about why a de minimis or minimal, kind of this low standard for IEPs is how the court should rule. Help us understand what they're saying.
Sure. So the school district has two major arguments. First, the statute was passed under the spending clause of the Constitution. And what that really means is that when states agree to enforce IDEA and all of its provisions, they've done that under a set of expectations that they believe they have to provide. So it's kind of like, hey, if you change this now, you're going to change the rules of the game on us. The second part is really focused on they feel the standard does have some bite and that it is working in schools today, that most circuits have adopted it, and that changes to the statute and guidance that has fleshed it out like that issued by the Department of Education shouldn't need to change the standard and doesn't indicate a real change in our education system of lifting the standard. We disagree with those positions, but they do have merit, and we see them throughout many cases in different scenarios.
Okay. Sounds like they do have some legal arguments they're making. Assistant Secretary, you also joined an amicus brief, a legal paper to the court, along with a number of former federal officials. Can you talk a little bit about what you said to the court in that legal brief?
Yeah, so clearly because of the importance of this case and the lower courts holding that kids with disabilities are only entitled to a more than de minimis educational benefit, we came together as former special ed officials going back to the beginning of the Department of Education with Madeline Will, who was the first assistant secretary for special education, Republican, Democratic leadership in the Office of Special Ed, to say, you know what, that doesn't make sense. It doesn't. It is incompatible with what we know is happening in classrooms every single day. It is incompatible with the statute. It's just wrong. So we filed this brief again. Republicans and Democrats came together and said, look, we know from decades of research what works for kids with disabilities, what works in the classrooms around academic supports, around behavioral supports. And we talked about that in the brief. What the research shows are actually meaningful strategies to help kids be involved in and make progress in the general curriculum. And then we made the arguments that, look, federal education law since 1997 has kind of moved forward in those high expectations, starting with the 97 reauthorization, ensuring that there were measurable annual goals for kids in their IEPs, and ESEA holding all kids to the same high college and career ready standards, reauthorized by the Every Student Succeeds Act as well. So that was essentially the arguments that we made. That look, this is inconsistent with federal law, and best practice tells us otherwise.
So basically, a lot of these laws that have been passed have been really moving toward this point of having a more meaningful standard. Now, one of the arguments I think that the school district is saying about how it may be difficult to apply this standard, but in your former position as assistant secretary, you interacted with a lot of state officials with respect to special education. What do you think the impact of this decision could be on states and local schools?
You know, about a year and a half ago, we issued some guidance that said that, you know, as a condition of FAPE, that the IEPs must be designed, all of the IEP, the goals, the special ed, the supports and services, the personnel supports, must be designed to ensure that the child has the opportunity to be involved in and make progress in the general curriculum, which is the same curriculum that applies to non-disabled kids for the grade, based on the standards for the grade in which the child is enrolled. We put out this guidance because that is what's happening. We needed to kind of officially marry the expectations of the general ed law, because of course kids with disabilities are general ed students first, right? And the general ed law says kids with disabilities have to be held to the same high academic standards, college and career ready standards, as reauthorized just this past year by the Every Student Succeeds Act. And this guidance says, you know, this is what you're expected to do. And it wasn't, you know, new policy. It was, in fact, what was happening in the ground. And we also know from the briefs from the National Association of State Directors of Special Education that state directors of special ed say this is exactly what's happening. This is happening all over the country. And then they also was an amicus brief filed by the National Education Association and also said this is what teachers do. This is the best practice. We have to hold to higher expectations, and teachers know that, and that's what they're trying to do.
So that's amazing. Both this large teachers union and the people on the ground responsible for implementing special education basically said this is a workable standard, this meaningful benefit. Lindsay, you were in the oral argument. You heard what the justices said. Any indication from their questions about how this case is going to turn out?
So it's like reading tea leaves. It's hard. But as I said earlier, I'm excited. I was excited to hear how much obviously this topic is incredibly important. And I was excited to hear how well versed the justices were in it. And it seemed clear to me, I hate to make a prediction, but it seemed clear to me that they really were bothered by the term de minimis. And Michael's definition of it captures why. So that would be, we certainly don't want a lowering or an enshrinement of that word. So they really talked about what is the right word, how do we capture it, and they looked at, I think we're going to see them, the language will be really carefully chosen because they talked about the meaning of each of these different words. But from my position there, it seemed like they were taking very seriously the idea that the lower courts are confused, de minimis is not enough, we need to do something here.
For those parents who are watching right now, what will it mean if the family wins? What will that mean for kids with learning and attention issues? And conversely, if the family loses, what could that mean?
Well, I think it's best to talk about it in terms of what will it mean if they raise the standard or if they clarify a standard that provides meaningful benefit, and what does it mean if we get a de minimis standard enshrined in law. If the family wins and we get a standard that tells us meaningful benefit, that's going to set a tone for all of the actions that happen across our state policymakers, right down into our educators in the room. It's going to send a message that we do need to, that the practice, which is holding people to high standards, grade level achievement, making sure progress means you are moving forward at a rate that we expect for someone in your grade level as appropriate to your needs, will be something that is something that I think we need to see more of. There's too much confusion. So if the family wins and that standard is applied, we'll see that. Frankly, if the de minimis standard, I'm very concerned about whether the de minimis standard would be accepted. And if it is, I think you'll see advocacy groups like NCLD and others absolutely walking straight to the doors of Congress to say this is unacceptable. Our students cannot be kept in schools that are simply giving them a de minimis education, more than little trivial education. What's the point of that? So I think you'll see real action from the community to demand a higher standard in law.
And when can we expect a decision from the court on the case?
Well, we don't know, but they have to issue something by the second week, middle of June, basically. So we think probably a little later this spring.
Okay, thanks so much. Thanks so much to both of you for joining us, sharing your expertise. It's really helpful to our parents. Thanks so much.
Thank you.
As you've heard, this is a very important case for kids with learning and attention issues and for special education and IEPs. Understood is going to keep you updated as the case develops. In the meantime, if you do have any questions about your child's rights, learning and attention issues, please do go to understood.org for free resources and expert answers to your questions. Thanks so much for joining us, and have a great day.